How do I introduce to you a veritable sage, Vedavyasa himself? And how do I introduce to you a combination of the Roman jurisconsult and a Brahma Rishi? It's a task, it's a very uphill task and it with trepidation, but it remains a pleasurable one. Shri K.Parasaran was born on the 9th of October 1927 to Keshava Iyengar, a seasoned doyen of the Madras Bar. He completed schooling at the Hindu High School in Madras in 1942 and graduated from the Presidency College Madras with a BA in 1946. He took his degree in law in 1949. He was awarded the Justice C.V. Kumaraswamy Shastri Medal for Sanskrit in his BA and the Justice Sir V. Bhashyam Iyengar Gold Medal in Hindu Law for his BL, along with the Justice K.S. Krishnaswamy Iyengar Medal for his Bar Council examination. He was enrolled in the Madras High Court in 1950 and in the Supreme Court in 1958. He was appointed Central Government Standing Counsel in the High Court in 1971 and was appointed Advocate General for Tamil Nadu on the 17th of June 1976 and resigned in June 1977. He was appointed Solicitor General for India in February 1980 and was appointed Attorney General for India from 9th August 1983 till November 1989. He served as President of the Indian Society of Criminology from 1984 to 1985 and was President of the Bar Association of India from 1984 to 1987. He led the Indian team to represent the victims of the Bhopal gas leak disaster in the proceedings against Union Carbide in 1984. He was appointed in 1986 as a member of the Permanent Court of Arbitration at The Hague. He was awarded the honorary degree of the Doctor of Laws by Annamalai University in 1989. In the year 2000, he was nominated as a member of the landmark National Commission for Review of the Working of the Constitution, which was headed by the former Chief Justice M.N. Venkatachalaya. In the year 2003, he was awarded the Padma Bhushan for his services to the nation by the President of India. And in the year 2011, he was decorated with the Padma Vibhushan by the Government of India and nominated to the Rajya Sabha in July 2012. In his career, an illustrious experience which by age, character, color and content and by sheer years surpasses the very age of the Supreme Court itself. He has appeared in several constitutional questions and most notably during those times in S.P. Gupta versus the Union of India, where after the arguments, we believe it was Shri Lal Narayan Sinha who got up and said that Shri K.Parasaran's written submissions are as good as a doctoral thesis. And maybe I dare say with humility that Shri K.Parasaran was one of the greatest judges that the Supreme Court never had. January 5th, 2013 would be a day etched in our memories, for that was the day in which we heard this sagely lion of Dharma who thundered in this very auditorium, which was opened for the first time that year. And when thinking about that day, I was redolent with what Gajendra Gadkar had to say in the full court reference for A.V. Vishwanatha Shastri, that Nakaschid Dhimatam Vishayona, that a true intellectual, there is nothing that a true intellectual does not know, and we realized the true potential of this statement on January 5th, 2013. And what we all felt was the music in our hearts we bore long after it was heard no more. Although all through the golden pages of Shri Parasaran's life, there is one message that ringingly sublimates. Dharma eva hato hanti dharmo rakshati rakshitaha tasmad dharmo nahantavyo mano dharmo hato vadhit, which is what Manu says. It's a Mahavakya for law and dharma as a whole. And for years of elevating experience, and there can only be, we all believe, only one K.Parasaran. As the ancient saying goes, there can only be one such person. Therefore, it is my pleasure to give the stage to Shri K.Parasaran. May I invite you to address this gathering.
Most revered, the Honorable Dr. Justice B.N. Sri Krishna, Madam Dr. Sri Krishna, Dr. Chitra Madhavan, the professors, lecturers, academicians and the brilliant students of the Shastra University. Truly, I stand with trepidation when I see three scholars in the first row, and in particular, only one is a gentleman, the other two are ladies. The entire knowledge he himself said, proclaimed, is vested in Saraswati, and she knows all languages. And my knowledge of Sanskrit is very little. This is my first handicap. And second handicap, that brilliant students are so brilliant, I don't know whether I will be able to survive their questions by giving correct answers. The third handicap, for the past 2 weeks I have had some ear infection, and as medical advice I have flown because it's a word commitment to Mr. Vaidya Subramaniam, who has the right and privilege of issuing mandamus to me. But what tempted me more is the function which is Samskrita Vaibhava. The Vaibhava may be a tautology, Sanskrit itself is Vaibhava. Well done. This is one of the greatest of languages. But I must congratulate this university because they have the courage to celebrate it in Tamil Nadu, while it's a matter of great controversy if you even utter one word of Sanskrit. This institution is already established a reputation, and I must start with congratulating students whom I am told yesterday won the moot court competition. I was not surprised when I heard it because if they participated, they are bound to succeed. Now I have been directed to speak on law and dharma. Dharma, we have had a wonderful exposition by Justice Shri Krishna, because when you say Krishna, he expounded dharma. That's the Bhagavad Gita. So today we had a replica by Justice Shri Krishna. And he also, when he was concluding in answering your question, referred to the motto written in the emblem of the Supreme Court, Yato Dharmas Tato Jaya. But in the High Court, it is not written as Yato Dharmas Tato Jaya, Satyam Eva Jayate. Do they conflict or do they the same? Is it a tautology or an oxymoron? Or are they the same facets? I had a few words I shared with you when I came here a few years back. But both of them coalesce, their own conflict. Because justice is not different in the Supreme Court, different in the High Court, different in subordinate courts. Justice is only one and integrated one. It does not differ from court to court. But why have they put law and dharma? Law is one facet of dharma. Dharma is very exhaustive. As the judge pointed out, it's not a word you translate into another word. It's a concept. It is a banyan tree. Because not only the trunk, it goes on living on all the, you are alone, but I've seen in those days, not now, the Adiyar banyan tree. That is Sanskrit. And why did I say it's a banyan tree? Because I am speaking a little about Sanskrit and Dharma before I come to Dharma, because the function is Samskrita Vaibhava. That was, it used to be said, Telliya Alin Sirvart Urivirai, Tennir Kayachut, Sirmin Sirainum, Nunide Ayinum, Annal Yanai, Anider Kurabi, Adperum Badayodu, Mandar Kirkan Nidalahunme. A king with a full army, with all his horses and elephants, can have shade under that tree. That seed is only a very small one. And that word, Samskrita, is maybe one word. From that grows the banyan tree. You can see dharma, you can see philosophy, you can see debate, you can see law, you can see science, you can see economics, you can see politics. There's nothing under the sun, no subject under the sun, which you can't see in Sanskrit. And that is the greatness of Sanskrit, and that's our heritage, of which we must be proud. But one has to shudder in some places if one thinks or even speaks about Sanskrit. Now, we say law and dharma, and I said, yato dharma tato jaya. Where do we get it? All wisdom comes only from Mahabharata. There are frequent references to Mahabharata by the learned judge. It comes from the lips of Gandhari. I must remember that. One of the greatest of devoted wives of the husband, who would make herself blindfolded, not blind. And every day before going to the battle, Duryodhana, he was an epitome of a model, a role model of a son's devotion to mother. Go and touch her feet. She will only say, yato dharmas tato jaya. That is, you see, she knows her son is in the wrong. She has to bless him. She only says, yato dharmas tato jaya. Because they will not serve from the path of justice and righteousness. That was the value which she followed. This is the greatness of our heritage and culture. The greatness I refer to because there are a lot of alankaras in Sanskrit. Now, it is not only when I told the Supreme Court in the Gita, a judge was looking at me sarcastically, satirically. How is he blabbering? Why is it in Gita? But Gita starts the first stanza. The first word is Dharma Kshetre. The first two letters are Dharma. It concludes by saying Himakurvata Sanjaya. The last word is Sanjaya. The last two letters are Jaya. Dharmo Jaya. That is what it is in the Supreme Court. That's why Yato Dharmas Tato Jaya. The Justice are rightly pointed out, it's only behind. The judges don't see it. It is they alone should see it first. Those who are appearing before him, they can come there for a result. And it only tells them, if you are on the path of righteousness, you win the case. But it is for the judges to see that they are always on the path of righteousness. This is Yato Dharmas Tato Jaya. Now let us see what law and dharma is. Some questions were put and answers were being given, pratyaksha, anumana, etc. Therefore, how do we establish something? Some question was also put on procedure. How do you establish a fact? Only by evidence. Not by mere evidence alone, and documents are orally, but by addressing arguments. Therefore, the arguments must be of a very high order. The Lord says in the Bhagavad Gita, Adhyatma Vidya Vidyanam Vada Prabhadata Maham. Among the disputants, I am the Vada. That is, he manifests himself, the commentators say, he manifests himself in those halls where the debate is of the highest order. And even there, he manifests himself in that argument which is the best. Knowledge should not be left in a dubious state. All doubts must be cleared by the generation of correct knowledge of truth. Doubt is the one impediment to fulfillment. The doubting man affects his own frustration, is what the Lord says in the Bhagavad Gita. Vada is truly a science. It's a sacrifice. It's a yajna for determining truth and should be understood and conducted as such. The noblest of minds have been the staunchest of disputants. Ability and honesty, amity and balance, fairness and fearlessness are essential to those engaged in vada or disputation. Ignorance and prejudice, untruth and deceit, bigotry and malignity are the very enemies of vada. The staunchest of disputants have been the fastest of friends in life. Debate is one thing, but at the end of the debate, there is no rancor, there is no enmity. You debate so that you find out where the truth lies. This is the essence of debate to arrive at the truth. I think I shared with you last time an anecdote of how on the same fact, two different conclusions were arrived at. It was in the context of astrology or nimitta. A gentleman had gone to Varanasi and naturally going on a pilgrimage, going to Kedarnath, Badrinath, etc., Himalayan trains. He had not returned for several years, a few years. The wife became worried. The neighbors are good people, therefore they gossip. He must have been washed away by the Ganges or been drowned in the avalanche. But she thinks her husband is alive. She goes with her flowers, kumkum, and decoration. She became very panicky. And when she was drawing water from the well, at that time an astrologer passed by. He asked him, "Is my husband alive?" He went to Varanasi, he has not returned for nearly a year. At that time the rope was an old one. It was almost in a position to give way. The vessel was, when he drew the water, that weight it could not bear. It gave way. The vessel went into the well. The astrologer said, "Madam, your husband is dead." In panic, she ran to another astrologer. He asked him whether my husband is alive. The same question. Because that astrologer said, he is dead. He said, he's talking nonsense. He's alive. He'll be back soon. Go and prepare a sweet which is lost for a couple of days or a few more days, so that when he receives, you can receive, when he comes, you can receive him with the sweets. She was happy, word of encouragement, because one must try to save life. Article 21, right to life, it's a precious life. But he had a logic. She goes home. Next day morning, somebody is knocking at the door. She opens the door. To her great happiness, it is her husband. She narrates what the first soldier said. And the second, he asked her, "I am smelling sweet. How is it you are preparing sweet? When the husband is not here, you don't normally prepare sweets." She told him both the anecdotes. They went to the first soldier. "Why did you say she is dead?" She was asking me whether you were dead or alive. So she was asking as to whether her Mangal Sutra is intact or is it gone. At that time, that rope gave way. Therefore, I cut this Mangal Sutra. I said, "She is dead. He is dead." They ran to the other astrologer. How did he give a different interpretation and it's proved to be correct? He said, "He did not know, I did not know. We have to go only by Anumana. If we have no knowledge of Pratyaksha." That incident he was interpreting. I must try to see if I can interpret in a different way and address an argument. I had an answer. The question was not whether he is alive or dead. Supposing he is alive but he never returns. Is she happy? Therefore, he wrongly understood the question. A wrong question gives a wrong answer. If somebody asked, "Can I smoke when I pray?" He was given a staff by the priest. Another man went to him, "Can I pray when I smoke?" Certainly, there is no time for smoke. You pray. You put the right question, you get the right answer. You put the wrong question, you get the wrong answer. The question is not whether he is alive, because she wants him to be back to her. At that time, what has she done? She had separated a pot of water from the well water. When the rope gave way, the separated water rejoined the well water. Therefore, I said, the husband will join the wife. Therefore, you see, this nimitta comes from where? From logic. That logic comes from where? Vada. That vada is one which leads not only to truth, but something which is hita, which is in public good, which will do good to others, which will save their life. This is the glory of wisdom and knowledge. Knowledge is very proud. I know so much. Wisdom is very humble. I know only so much. The first man had the knowledge, but the second astrologer had the wisdom. A lawyer and a judge, what is required is wisdom. That is the law and dharma. Sastrajñah, K.Parasaran, Kusala, Vakta Nacha Krodhana is what the Mrichakatikam says. He must be learned in the laws, but he must be learned in also other subjects. It only says Sastrajñah. It does not say Nyaya Sastra. K.Parasaran, Kusala, he must know the hanky-panky of which the parties are capable of playing. Both the private litigants as well as the government. You see what all have happened in the government when the previous government goes and a new government comes. When a new government goes, another government comes, many more things will come. Therefore, the judge must be able to appreciate the hanky-panky which they are capable. Vakta, absolutely dignified. The court, not only he must keep dignity, but he must ensure that everyone keeps dignity in court. There is no levity. nacha krodhana, never lose his temper. Once a judge loses his temper, there is no guarantee his judgment will be correct. It is not only what the Shastras say, I'll come to necessary to the text, but the Privy Council said it as early as 1945. Judges are no doubt human, and their patience is often sorely tried by counsel and litigants. But it is to be regretted that judicial temper should even appear to be lost, not lost. But parties who are responsible to bring about that situation have no business to complain. This is the warning in 1945 Privy Council in Basileis versus Basileis. Now, coming to the heart of the matter, law and dharma. When you have got a profound scholar, I don't want to dabble about it. But he himself gave a lecture at Delhi. That was a speech delivered under the auspices of Search as early as 2005, and his speech is still ringing in my ears after 11 years. And it was on the subject of spiritual heritage, where he has elaborately dealt with Dharma. And as Sri Krishna has said, the sanction being law, I had it collected and sent to Law Weekly for publication after taking his permission. They had also had it reported in the SEC. The sanction behind law is the collective will. The collective will, this is in the context of Dharma he is saying it. The collective will must of necessity reflect the accepted values of contemporary society. Though such values may vary depending upon temporal and spatial constructs, there remain certain core values which are accepted as immutable and consummate. The justice of laws and the obedience commanded by them depends on how closely they resonate and core values. What is important is universality of law. Basic laws are eternal and universal. Other laws are not universal or eternal, like for instance partition, succession, intestate succession, marriage, divorce. They change according to times. They are different in different countries. But basic laws are eternal and universal. They don't change. That's why we have got human rights, to which most of the countries are parties to human rights. Right to life is a basic feature. It's a human right. It's not only human right, even animals you are seeing. The only exception is if you are a non-vegetarian, you have got a right to kill. But if you are not a non-vegetarian, or even if you are non-vegetarian, if it's not for your food, if you kill, then it becomes a sin. In Tamil we say, Konna Pam, Tunna Poch. Rama says it to Valmiki. That's the only exception. And debate is going on. Of course, that's a different story. Cow, one should not. That's a different story. Different is going on vegetarian. If everybody becomes a vegetarian, we will starve for vegetables. We won't get vegetables. And in 1942, in the book Our India, Meenu Vasani wrote one chapter, The Puzzle about India. He says, poverty amidst plenty. This poverty amidst plenty is because agricultural economy was ignored by successive governments. And therefore, poverty amidst plenty. Corporate sector economy is also necessary. But agricultural economy is also very necessary. If it had been taken care of, there would not have been so many suicides of farmers. Of 20 farmers day, media will say 40 farmers committed suicide because 20 of them would not have been agriculturists at all, but they would have committed suicide. But this is a fact of life. Now, one more passage I am reading from his speech at Delhi. Both law and dharma act as means to keep under check the primeval instincts of the social constituents. The greater such restraint, the more refined and evolved is society. Any system of rules for orderly transaction in society must of necessity pay obeisance to this concept of reasoning. Whether we perceive law as the means to attain the abstract goal of justice or as the means of social engineering, we have to ensure that this instrument is tempered and imbued with cherished values of society. Now, having said so much, a lawyer always go by precedents, and precedents are either judgments or eminent judges. Having quoted one eminent judges of the Supreme Court, former judge, now I will quote another judge, Chief Justice Rajamanna. Chief Justice Rajamanna of the Madras High Court and Chief Justice Chagla of the Bombay High Court were two great renowned Chief Justices. It was in a centenary speech at the Madras High Court, centenary celebrations of the Madras High Court, where he was speaking about law and dharma. He says, I quote, "Law is something more than a mere secular code of conduct. It is something more and something higher than the contents of any statute book or volumes of judicial decisions. Its foundation is the concept of justice, an instinct for which is deep-seated in our moral being, though it's incapable of precise definition. The content of the concept of justice may vary from age to age, from country to country, and at different stages of social development. But its categorical imperative is constant. That is, the common denominator which is constant is dharma. That's very important. There may be swadharma, kuladharma, shankadharma, desadharma, lokadharma, and yukadharma. You can even say vritti dharma, lawyers, judges. We are all carrying out an activity. But dharma is constant. No legislation can last which does not flow from this foundation, from this fountain. It's often said that legislation represents the voice of the people, and the voice of the people is the voice of God. Our election speeches, Makkal Tirpe, Mahesan Tirpu. You see, it also, angels quote scriptures, but others also quote scriptures. The systems and laws made in such utter disregard of the voice of God systems and laws made in such utter disregard of the voice of God may appear to meet with success temporarily, but sooner or later they are bound to perish. No law which does not satisfy the ethical conscience, that is very important. When we say current social values, the values must be ethical values. Ethical conscience of the community can survive. It is therefore essential that the ethical foundations of law should neither be forgotten nor neglected. Law is not an isolated technicality. It is a part of history, a part of economics, a part of sociology, a part of ethics, and a philosophy of life. In the words of a great English jurist, law is a force or tendency which makes for righteousness, that is dharma. So, dharma, Chief Justice Rajamanna says, is righteousness. Stand steadfast on the path of righteousness. You have conformed to dharma. If you have conformed to righteousness and dharma, you would not have disobeyed any law. Therefore, it is said with legal maxim, ignorance of law is no excuse. Not because one can violate the law and then say, I did not know the law. Because if one acts according to dharma, according to good conscience, if he is righteous, he would not have violated the rights of anyone. The emphasis today has been too much on rights. Nobody speaks about duties. There are no seminars on duties. One PIL was filed, notice was issued by Chief Justice Anand. I was appointed as amicus. And such good cases die a natural death. It was almost made infectious. No inquiry was made, no hearing was made. Because nobody likes to be talked about duties, Therefore, everybody wants rights. We have to today talk about women's rights. And Justice Krishna referred to the Muslim women claiming a right of entry in Bombay, and the Hindu women claiming a right of entry in the temple at Sabrimala. Therefore, it is a tragedy that in a country of India, we have to hold seminars for rights of women. A country where women were held in the highest of esteem. Yatra naryastu pujyante, ramante tatra devataha, yatraisatu nabujyante, tatrasa apalakriya. Only places where women are given their due place of pride, there whatever you do will bear fruit. If you don't give them that due place, then whatever you do will not yield results. If you want learning, you must go to Saraswati. If you want wealth, you have to go to Lakshmi. If you want Shakti, you have to go to Parvati. and everything had been good. The mistake was in interpretation. Interpretation by the conservative scholars, the people like Prataparudra, finished the women with regard to their right to succession. Widow daughter-in-law was finished. There were also people like Vishwarupa, Vijnaneshwara, who interpreted it correctly. One illustration, for instance, a predeceased son's widow is entitled to a share. But they were denied the share and thrown to the wolf. Hindu Women's Right Property Act to be passed. That only gave them a woman's estate. Then till 1956 Hindu Succession Act came. The text was misinterpreted. If a son predeceases the father, the widowed daughter-in-law is entitled to share. Because the text was how misinterpreted was, a rule need not be stated. An exception had to be stated. The rule that the daughter-in-law gets need not be stated. But when they are giving the order of succession, it included the mother and the grandmother. Therefore, that means the mother and grandmother of our husband, not hers. Because his property goes by succession. Why? Because all the ladies had to be taken care of. This was the text. The exception is normally they don't inherit. Why? Because when the son is alive, he takes care of them. The mother and grandmother, he takes care of them. The text, sometimes I forget the text also. Therefore, even Manu's text has been misinterpreted. Pita Rashati, Bharta Rashati Yavane, Putra Rashati Vardogi, even that is mistaken. It is not as if the women of the position are reduced, but it is casting a duty on them to see, don't see that they suffer. Everywhere, because Dharma talks only of duties. It does not talk of rights. Therefore, it imposes a duty on them, please take care of them. This is interpreted by approaching it from the wrong end, namely rights. It is not to diminish their rights. Having given them their right, how will it diminish it? Eminent judges have failed in interpretation. Forget Prataparudras. Vardacharya failed in the Supreme Court, in the Federal Court, when interpreting Hindu Women's Property Act. He interpreted separate property means it includes partition in the joint family property, it includes self-figured property, but it will not include the property of a sole surviving co-person. An eminent Hindu law judge who knew Sanskrit. Another eminent judge who dominated the Supreme Court bar, I should not tell the names, I'm sorry, I apologize if I am told Bharatacharya. You can guess who this is. He dominated the Supreme Court bar. He held a father is not bound to meet the marriage expenses of his daughter unless he has inherited ancestral property. He need not meet it from his self-figured property. The text says, Prapte dvadase varshe yakanyam na prayachati mata chaiva pita chaiva jeshtabrata tataiva cha trayaste naragam yanti drishtva kanyam ratastulam. Is a text. He says recommendatory and not mandatory. The Hindu Women's Right to Maintenance Act now provides Maintenance and Adoption Act. I make a mistake in taking. It provides, in an explanation to a section, maintenance includes marriage expenses of the daughter. You see how the mistake is not in the ancient text. They are being condemned, they are being ridiculed. The mistake is interpretation. Judges also interpret. They can also go wrong. Commentators can go wrong. Nobody is infallible. But if your vada is correct, sadvada, and not Vetandavada or Jalpavada, you get the result. The result always advances public good. Because if you are on the path of righteousness, Dharma does not do injustice. Dharma only enjoins people to do their duties. And everybody in this country performs his duty, whose rights will be affected. What is the need for a 32 petition? What is the need for a PIL? And today's Supreme Court is flooded only with PILs. Supreme Court has got a Dharma. And lawyers have got a Dharma. The executive has a Dharma. The judiciary has a Dharma. The legislature has a Dharma. They are demonstrated by anecdotes in our scriptures, in Sanskrit. But are they following the path of righteousness? This is separation of powers. The Supreme Court zealously guarded the separation of powers when interpreting the Constitution and striking down the NJAC Act. Usually executive shall not come anywhere, they are untouchables. But do you respect the separation of powers when it comes to executive? Today I will say there is no area where there is a separation of power in favor of the executive. Because Article 21 is right to life. All facets of life have been read into Article 21. Everything in this world must be directly or indirectly related to life. Is it unrelated to life? And they have written 21 life. The Supreme Court miserably failed in ADM Jabalpur. Then woke up. They said right to life is conferred by 21. Right to life is not conferred. 21 only says no one shall be deprived of his life except by life and liberty except by authority of law. He says you can't deprive the right to life. Then is already there as an inherent right. But later the pendulum swung the other side because they have to build up the image. So everything which is a facet of life, whether directly or indirectly related, is brought under 21. Having brought in 21, contrary to what the founding fathers said, they read the American due process in Article 14. Even substantive law legislation are tested under Article 14 on the doctrine of just, fair and reasonable, on the doctrine of irrationality, on the ground of discrimination is all right, the irrationality. How do you test the validity of a plenary legislation on the ground of arbitrariness? Whose arbitrariness? There are so many members of the House, of the Parliament or the assemblies. Whose mind you are analyzing? One might have, like a semaphore, voted along with the party because of the whip. One might not have understood and voted. One might have misunderstood and voted. Several minds have gone into it. Can you ever apply the doctrine of arbitrariness to such? Can you apply the doctrine of irrationality? Can you apply the doctrine of legitimate expectation? Can you apply estoppel? They can't apply. But therefore, it is the view of the judge as to the reasonableness or rationality and the view of the legislature. You see, the best process, better would be, leave it to them to do their job. Then you have the judicial review. It's a basic feature. Nobody can touch it. Then you exercise your power. You have the advantage of somebody doing it. When we do it, we won't see the mistake. When somebody has done it, when you examine it, it's easy to find out whether it is right or whether it is wrong. There's also a protection because two minds have been applied to it. They are not in a great hurry. I have preempted, decide in advance. They must always allow the executive to perform its functions, the legislature to perform its functions, and then exercise the basic feature, your judicial review, and correct them. Not that you can't do it. Any appointment, after appointment, a writ petition. Before appointment, a writ petition. Any scheme they want to do, in policy matters, apply Article 14. You preempt, you do this. You see, they need not always be right. The executive or the legislature need not always be right. But it is not as if the court should interfere and should always say it is wrong, therefore the right thing should be done. There are areas where there may have to be a compromise so that the society gets on without any problem. There's an interesting book, one of the greatest of lords, Lord Samson, and the limits of the law. This aspect is discussed. He says, I'm not omitting the previous paragraphs and pages to cut short the time. So it may appear as if I'm starting abruptly, but the idea you get it from it. I think that their attitude, which is shared by some judges, overlooks some fundamental features of political process. Democracy requires a minimum degree of social cohesion and tolerance of internal differences in order to function properly, but provided that these conditions exist. I would like to suggest to you that politics is quite simply a better way of resolving questions of social policy than judge-made law. Public law questions which come before the courts are commonly presented as issues between the state and the individual, but most of them are in reality issues between different groups of citizens. Take Sabarimala. There are two groups. One group of ladies saying we will go. Another group of ladies saying we should not go. Even amongst the ladies themselves who fight for their rights, there is a difference of opinion. You can't mechanically apply Article 14. I don't want to discuss it here. Sub judice, I am myself appearing in the matter. I never discussed a case in which I have appeared. Whether it is before the case is heard or after judgment is delivered also, I don't debate. The only exception I made was appointment of judges, in which the judges have strong views, some lawyers have strong views, I have also some strong views. Who is right, who is wrong, God only knows. This applies particularly to major social or moral issues and more generally to issues on which people hold strong and divergent positions. The essential function of politics in a democracy is to reconcile inconsistent interests and opinions by producing a result which it may be that few people would have chosen as their preferred option, but which a majority can live with. This is the accommodating the minority. I mean minority in several senses, not in one sense alone. Political parties are rarely monolithic. Although generally sharing a common outlook, they are unruly coalitions between shifting factions united only by a common desire to win elections. They therefore mutate in response to changes in public sentiment in the interest of winning or retaining power. Very important. Churchill was quoted by Krishna here. The little man going to a little room, a little booth, dropping his little piece of paper. And today, how does he drop the paper? If enough papers, currencies have come into his pocket. Corruption starts in the seeds. Then what will be the tree which grows? We are having only corruption cases in court. And Supreme Court does not decide any other case. And even there, the separation of powers, forget one type of separation of powers. There are also other aspects involved in that case. Complaint or FIR is called 32 petition, which has to go to the station house officer. Supreme Court is converted into station house officer. Then investigation order. Supreme Court is an adjudicating authority, not an investigating authority. And it says, no, we are only monitoring. Monitoring investigation, I don't know, I don't feel that it is adjudication. You are still monitoring only investigation. As early as 1945, the Supreme Court said, don't interfere at the investigation stage. They should not come at the investigation stage. There are remedies. I don't say there are no remedies. They follow the Privy Council. After following it, this is what they are doing. Already ordered investigation. You must leave it at that. Then they say, file periodical reports. What are the reports? They are nothing but case diary under the criminal procedure of the police. That's all. He said, if the accused is entitled to know the case diaries. So that's the Supreme Court Act at the stage of case diary. All right. After having got the case diary, they appoint public prosecutors. And there are exceptions. In the state, if a particular official is involved, officer is minister is involved, etc., there may be a court may say, yes, this is good, it's no good. They have got the power. That's a different story. Not only you appoint public prosecutor, then you say they will file the police report before us. Then only go to the magistrate or special judge. Who is this preemption and the hurry? Allow the court as cognizance to monitor the investigation. If it makes a mistake, you have got the High Court. If they make a mistake, comes in SLP. Not that they say no petition shall be filed in any other court. Under Criminal Procedure Code, they have got a right to move for the High Court for question. Under the Constitution also 226. And the House of Lords said, it was in 10 House of Lords cases, the House of Lords held that you can't abolish the forum of appeals and courts or create one. You can't create an appellate court. You can't take away an appellate court. How did the Supreme Court deprive the High Court of its power? They started with company cases, general body meeting, injunction suits filed in different courts. And you have one court or other, district courts, sub-courts, high courts, different states. Therefore, they said, no, go only to one court. You have started extending it to criminal cases also. You have started investigation. Now, if the Supreme Court takes over an FIR as a 32 petition, if it monitors the investigation, if ultimately it goes to the trial judge, if supposing 10 of them are really culprits, one of them is an innocent man, Has he a semblance of a chance of acquittal? Very difficult for anybody to sue. Best thing is allow them to go by the procedure. 21 says procedure established by law. No order of Supreme Court, I am not decrying. In fact, they have done a yeoman service to the country. They have protected democracy. They have protected life. Yeah, forget the aberration of the AD Jabal Court. No court in any country has done so much for our country as the Supreme Court. But then there are areas where they should be prudent. Judicial wisdom, judicial statesmanship. You see, public litigation, what is very essential is judicial statesmanship, judicial restraint. And particularly when it deals with life. And now see on policies how this author feels. They are instruments of compromise between a sufficiently wide range of opinions to enable a program to be laid before the electorate with some prospect of being accepted. The larger democracy is and more remote in political class from the population at large, the more vital this process of meditation is. It is true that the political process is often characterized by opacity, fudge or irrationality. And who is going to defend those? Well, at the risk of sounding paradoxical, I am going to defend them. They are tools of compromise, enabling divergent views and interests to be accommodated. The result may be intellectually impure, but it is frequently in public interest. Unfortunately, few people recognize this. They expect their politicians to be not just useful, but attractive. They demand principle, transparency, and consistency from them. And when they do not get these things, they are inclined to turn to courts of law instead. The attraction of judgment law is that it appears to have many of the virtues which the political process inevitably lacks. It is transparent, it is public, above all, it is animated by combination of abstract reasoning and more moral value judgment, which at first sight appears to embody a higher model of decision making than the messy compromises required to build a political consensus in a parliamentary system. You may have messy compromises if it will bring law and order properly, if it will maintain the society, there will be no problems. Take, for instance, this Jat reservation, where the Supreme Court judgment very probably is correct. I am not joining issue. But see the fallout of the Supreme Court striking down the Jat reservation. We all know what are loss of property, loss of life, how the modesty of women were trampled upon in Haryana. Therefore, I don't say the reservation is right or constitutional. Supreme Court, as we have written, is one of the greatest scholar judges today at the Supreme Court, Justice Rohington Nariman. So I am not joining issue with the judgment. But you see the follow. Supposing they are able to arrive at a political compromise and there is no law and order problem. Supposing it is tolerated. Therefore, allow this process to go on. Now they are thinking of legislation. At that time it was not legislation. Now again it will be tested. How do you go about it? On the contrary, you see the other matter. The Mandal Commission. There's a law and order problem. Lives were lost, agitation. The matter went to court. They kept it sub judice. Allowed the time to lapse. Acted as buffer. Feelings died down. Then questions were framed. 9 judges sat and decided. The problem was solved. There are situations where, that is, Kala Dharma we say. Today it may not be good to do it today. You may have to postpone it. These are the problems. In fact, the government had this problem in the Ayodhya case. They passed an ordinance and also a presidential reference. The president was reluctant to, and he was right, referring the questions to the Supreme Court. And in fact, Supreme Court had refused to answer the reference. He was advised, I don't want to say, people are not involved in that advice. He was advised, it is not as if you are not correct, probably you are correct. But then we want time, because if there's so much of agitation in the country, somebody to as a shock absorber for some time, so that the matter may be dragged on. It is on that reasoning that he cleared the papers. Though under the Constitution, it is said on second time, he has necessarily to give his assent or clear the papers. They expect their politicians to be not, I did that, it is public. Above all, now we see also here, when it comes to government, Right to Information Act. When it comes to court, no right to information. Now politicians are agitating. Today's newspapers you would have seen. No right to information of political parties. When it comes to me, no. When it comes to you, yes. Right to Information Act. Agitation. They will fight for the right information which the government. Why? People who are not in power will fight the government for information. People in power will say no information. The court does not want to show everything is openly heard. What is the right to information? But appointments, sometimes controversy arises. Is there anything available? Article 1, I think my time is up. No? I can go on. You must cut me short. Lawyers, once they start, they won't finish. And the Supreme Court seniors, the meter runs. Till now, by their fees. Hereafter, our fees also. We'll go on talking. And if I stand up, I'll go on talking. What's the time now? Till 12:30. Till 12:30? Very good. I'll be keeping my eyes on the clock. Therefore, they say, it's a very interesting discussion in this book. Therefore, there can be compromises, and very, very interesting passages are there. I've cut short the time. Therefore, the separation of powers doctrine, that's also a basic feature. Judicial review is a basic feature. The Supreme Court's contribution is immeasurable. One, the citizens of this country must be thankful to the Supreme Court. But there are areas where it will be desirable that they exercise judicial restraint and judicial statesmanship. Particularly, and PIL is taking too much of court's time. Criminal appeals are pending. Civil appeals are pending. Accused are languishing in jail. Is it a pressure to him to get an acquittal after having suffered most of the sentence and then get an acquittal? Therefore, the law must must follow along with the rule of justice, the concept of justice. That is Dharma. That is law, Dharma, justice, politics, all these things have to be seen together. Politics is also play a great role. When I say politics, the word politics has acquired an odium nowadays. We say in anything and everything we say, oh, there's a lot of politics. Cricket we say, oh, it is too much of politics. Something else we say, yes, there's politics. It has acquired an odium. On the other hand, it is politics which should be above all these controversies and should be the essence of the very life of the nation. About politics, the Mahabharata, Shanti Parva, this is what it says. Then I can read the Sanskrit verse also, but I want to cut short the time. The translation I am reading. When politics becomes lifeless, the triple Vedas sings. All the dharmas, that is, the basis of civilization, howsoever developed, completely decay. When traditional state ethics are departed from, all the bases of the divisions of individual life are shattered. In politics are realized all the forms of renunciation. In politics are united all the sacraments. In politics are combined all knowledge. In politics are centered all the worlds. Politics means there's been the political science. Politics should be a science and for the good of the people. But politics we have seen how it has been developed. Why is it so important? Because it is they who govern the country. Because today, both the judiciary and the executive govern the country. But it is in a democracy, it's the executive which governs the country. Therefore, whether ministers, whether executive, legislature or judiciary, it is they who should set the example for others. If they come under such controversies, people will also misbehave. Why? Because this is both mutual. You vote because it is given. They come to power, they run after that. There is some discussion went on about Dharma, Artha, Kama, Moksha when the previous speaker was speaking. As he rightly said, Artha is a means. You can't ignore money. Money is also important. But Dharma is a constant factor everywhere. Money has to be earned, but earned by the right means. If there is no money, is less than a human being. Panam padaram payum. Not only that, Dharjayat Purushasya Bandhavajano Vakyena Santishtati Sustigda Subhikvikandi Subhuda Spari Bhavantyapataha is what it says. A wife will not listen to him. A mother will discard him. A father will not take care for him. Money is the most important. I forget the stanza, very telling one. I tell you, Varam Varam Satu Jalagni Madhyam Drumalayam Pakvapala Ambu Bhojanam Trinani Sayya Paridana Valkalam Na Bandhu Madhye Dhanahina Jivanam. Varam Vanam, you can as well go and live in forest. Which forest? Vyagra Gajendra Sevitam, infested with tigers and elephants. Drumalayam, live abode a tree as your abode. Pakvapala Ambu Bhojanam, eat fruits and water in the forest. Trinani Sayya, lie in the grass as bed. Na bandhu madhye dhanahina jivanam. Money is necessary, must be earned in the right means. After having this for the sustenance, for you to serve the community. If you don't have the means, you won't be able to serve the community. That's why Shankara says, Deyam dina janaya chavittam. So if you have got enough wealth, see that you distribute it dina janas. Therefore, for that also you require money. But all the denominator, as Chief Justice Rajamannar says, the common denominator is Dharma. And if you don't set an example, others have no example to follow. If you set a wrong example, they will easily catch it. Oh, is he not doing it? Why should I not do it? That's what the Gita says. All of you know of that very familiar stanza. Yad yada charati shreshtaha tad deve tharo janaha sasat pramanam kurute lokatad anuvartate. If whatever action a great man performs, common men follow. And whatever standards he sets by exemplary acts, all the world pursues. If he sets up a good example, they follow. But if he sets a bad example, they follow the bad example. But he said, our text, Sanskrit text, as it is not as if we say, because of Pushpa Marma in that day, and it is not in that sense. But all these things, they were able to conceive. Whether it existed or not, it is not as if they could not conceive. We see in the Puranas, Parameshwara takes one jata, throw it away. Bhutaganas come. Will anybody believe it? No, Anan will believe it. But today we have got the cloning from one air. How does it get? They were able to conceive everything, whether it was there or not. One need not be fighting saying, which was there in the Vedic days, another saying, they are all talking nonsense. But they were able to conceive of these matters. And today I refer to it because today it is a coincidence, is Mahashivaratri. It has very relevance, great relevance. Why? Why is Shivaratri? Why is so great relevance? Because Shiva means saturated auspiciousness. Therefore, today is a day of great auspiciousness. Not only that, when I said Shiva auspiciousness, I'll tell you a very interesting anecdote. A couple married, they are in honeymoon. He is a man who employed in the army, in the front. A message comes, terrorists have entered, immediately come here. No time is given for reporting. How will that couple who are recently married in honeymoon feel at that time? He has to go. She has to give permission. She is so disgusted, but still she can't say, no, you can't go. And she wants to curse somebody who has called him. At the same time, he should also be auspicious. So he says, Kacha kacha shitet kanta pantana santute Shiva. Very rude, very, all right, go, get out. But on your path, let everything be auspicious. Pantana santute, that Shiva, last word alone, soft. All things are Rudragara. Next line, Mamapi janma tatraiva bhuyatyatra gato bhavan. She can't say, I will die, inauspicious. So, let me be born in the place where you will be there. I will die. But even if I die, let me be born in the place where you will go. This is the Alankara, this is the beauty of Sanskrit language. You shouldn't talk something inauspicious, but you want to express what will happen. You are getting disgusted, but you are discharging your duty. This is Dharma. This is Dharma for what? For him to perform his duty according to law, because he has taken the service of defending. Join the army. That is his Dharma. That's why I am saying that everyone takes a resolve, I will perform my duty. A father towards his minor children, a wife towards his husband, or her husband, a husband towards her wife, towards the wife. The Privy Council said as early as 8 months in the Privy Council, Kamachi Saiba's case, not Kamachi Saiba, the Chivanga case, said the father-in-law is the venerable protector of the daughter-in-law. In a very leading lawyer, his daughter, there's some dispute, some maintenance. Maintenance had been ordered against the father-in-law's assets also. The court was asking the question, how is the father-in-law like? So he phoned me up. I guess we are one of my very good friends. He phoned me up. I said, the Privy Council, I said it, show it to them. He is the venerable protector. The maintenance order was sustained. The law of Dharma, therefore, it is righteousness which is very important. Take, for instance, the cricket match, corruption we were talking, only one instance I will give. I've got a few more minutes to go. Justice Oda has given a report. What's the report? The report is, I believe, should be verified, but that's what I believe, recommending to consider to permit betting in cricket. Is betting to be permitted or not permitted? Is gambling good? We know the result of what happened in the gambling in Mahabharata. But I have no right to say it here because I defended the betting. A horse race. I argued that it is a game of skill and not a gambling. Gambling is there, but predominantly it's a game of skill. Of course, interpreters, I told you, I don't know whether I am the right interpreter, wrong interpreter, conservative or the liberal. I said, you see, that's where they are. Who will conquer my horse? Come on. Is it not a betting? Somebody may. Therefore, it's a sport of kings as well. The elephant is the horse is one of auspiciousness. Therefore, that game is being maintained, its efficiency has to be maintained. Bhagavad Gita was told with 4 horses on the chariot, the 4 Vedas manifested as the 4 horses. He could have told on so many other places. Arjuna could have asked earlier, he could have asked later, in the battlefield. But what have that to do with gambling? That's a skill. The jockey, the owner, the trainer, the size. So many are involved so many times. I went there. I went to the race course. I attended about a dozen meetings. I went to each one of them and asked them, they wait. The class 4 hours will go on winning. When it goes to top weight, it wins. It goes to class 3. Then runs with low weight. The sprinter, the stayer. He will run a sprinter in a stayer race of 1 mile and odd. It will run 6 furlongs first and then get defeated and then fall out. That nobody will only see the record. So you put it in a stayer twice, then you put it in a sprinter, you must pay upon it. It's a sprinter or a stayer. What's his pedigree? It is also skill. But to say it is a game predominant of skill or gambling is a moot question. Therefore, now the Supreme Court says, retired Chief Justice, in his report says, permit betting. It is because they were making money, all this bank fixing happened. And you add to it another way of making money. It is certainly not in keeping with the Dharma. You can enjoy the game, but why should you bet on it? Therefore, the areas, but popular support. So today's newspaper, I say, except horse racing, all gambling is bad. Some item, news item, so or somebody. That is why, because the community accepts it. The people are prepared to accept it and go and pay upon it. That may be a minority only. The majority may be against it. But it's a compromise in a society. This is one example. Like that we can envisage so many examples. Society has to live as a community. They have to live on compromises. They have to live on adjustments. They have to live in realizing this is my duty. They have to live tolerating others, give and take. So that by mutual cooperation, mutual tolerance, mutual love and affection. And the best of it is in our 2 itihasas, the Ramayana and Mahabharata. Ramayana is a itihasa of sacrifice. If the situation demands, one is prepared to sacrifice. Bhagirath sacrifice brought the Ganga. Ganga Jalanava Kadika Pita is what Shankara says. Dasaratha sacrificed his life when he could not feel the separation of the sun. Rama sacrificed Sita's sacrifice. It is not Rama's story, it is Sita's story. Sita Ya's Charita Mahata. Rama is only Ayana, the righteous path on which he passed. Sacrifice. Jatayu's sacrifice. See, gives up his life. Why? In protection of a woman's right. He is the greatest hero of Ramayana. A woman is being abducted. I am here, I sacrifice my life. A bird. And Rama tells Lakshmana, first he mistakes him. Oh, he must have said, swallowed Sita when he sees the scene there. Then when they go, when they realize the truth, he says, Sadhu Vakalu Dushyante. Even here we are able to see sadhus. A true sadhu is one who is prepared to sacrifice his life to protect a woman. That is Jatayu. So many heroes in Ramayana. Sita's sacrifice. Bharata's sacrifice. He lives in Nandigram. And Rama tells Vali, that he is the ruler, he is the trustee. I am here as his representative. He does not say, I am the king. Atanti Vasudham Krishnam. Abhayam Anyeta Parthivaha, he says. That is, it's a trust. What is vested, the power which is vested in the three channels, the executive, judiciary, is a trust. That trust has been performed as trustees. For a sin of breach of trust, there is no salvation, no redemption. Setum Drishtva Samutrasya Ganga Sagra Sangamam Brahmatapim Chaitanya Mitra Drohi Namunchate. Three sins. Mitra Drohi, Kritagnascha, Yasya Vishwasa Gataka, Taraiste Naragam Yanti, Yavas Chandra Divakaro. Mitra Drohi, Sain and Rimantam, Kritagyaha, Yasya Vishwasa Gataka, it's a breach of trust. They are all in according to the constitution, which is our Dharma, one judge has said it. It is our supreme Dharma. The power is vested in the executive, legislature, and judiciary. And all the three should stand steadfast on the path of Dharma. Why? Because they are trustees elected by the people to govern them. And if they commit a breach of trust, the consequences has to follow. Thank you all for your patiently listening to me. And I have come with I came with a little preparation, not much time.
I've got two questions.
I will post two questions. I requested him. Sometimes I hear, sometimes I have a problem because of the infection. He has put the question in writing for your benefit. I am reading it. In your decades of experience, what is your opinion on the persuasive value of Dharma in Supreme Court and other courts? Is it increasing, decreasing, unchanged or ignored? You see, ethical values, everybody talks. If you see the newspaper, the Supreme Court every day passes some strictures against somebody. It is better courts are not restrained and don't pass strictures because he has no remedy. But Dharma does play a role in courts also. That is, they call it justice. Justice according to law. But law can be bent, not broken. The Constitution preamble starts by justice, political, economic, etc. First it starts with, the word justice is the first word in the preamble. It permeates the entire Constitution. Why do I say so? Because the Supreme Court is the highest adjudicating authority whose power of judicial review is a basic feature and has done so much for the country. So, and that Supreme Court is conferred a power under Article 142 saying to do complete justice between the parties. Therefore, the complete justice, how should you say they are administering justice according to law? Why complete justice? Therefore, that is the ethical value or the Dharma. That is the Dharma of a judge, the judicial Dharma. The second question is, if Dharma can be classified into political, economic, social, religious, etc., which section of these has law been capable of handling effectively the most? Why? Why not? If Dharma can be classified. You see, Dharma itself is not classified as political, etc., etc., etc. Political, economic, social, religious activities have to be themselves to be modulated by Dharma, ethical values. Therefore, in each one of them, there are certain values have to be followed. Politics, as I gave one example, how ethical values have to be followed both by the voter and by those who are voted to power, not to be taken away by corrupt motives. Like that, economic values. The economic values means, for instance, corporate sector economy is one aspect. Agriculture economy is another aspect. So this is, in those areas also, you must do dharma. Therefore, the policy decisions are taken to advance the good of the public. The advancing the good of the public is their economic well-being. Therefore, their ethical values. How do you advance it? Like that, every one of them, social. Socially, there also ethical values are there. Moral values are there. How you conduct yourself in a societal feature with so many people having, this is a pluralistic society, that's very important. There also the ethical values, that is moral values, thing which your conscience will say, that is, for instance, it is Saint Germain said it, as to how you should be dictated. He said, just as a small lamp in a fully dark room throws light and shows every object in the dark, every object you can see. Every man has been bestowed by Almighty the Creator with good conscience. That good conscience is your right. That good conscience is the Dharma. It tells you which is the dharmic path. But knowing this is the dharmic path, the man goes and commits theft and puts it in his pocket. He knows what he is doing is wrong. Therefore, you take every aspect of life. When you are doing something wrong, your good conscience will say it is wrong. And therefore, whether it is economics, politics, social, anything, it is your good conscience which says this is the right path. Needi vazhuva nerimurayil mediniyil ittar veriyor idadar idigunathor. Nerimurayil ittar. Now that wrongly translating ittar means one who gives, not that. Nerimurai, the path of justice, the path of righteousness. For those who stand steadfast on the path of righteousness and walk on that path, they are periyor. Those who stir from that path, idigunathor, pattangilva. These are the only two castes. There are no other castes. But every day is a fight for reservation on caste. Your reservation, your reservation, my reservation. This is the Dharma aspect of Dharma. I did not deal with both of them in a comparative way because I wanted more to conform to Samskrita Vaibhavam. That is, whatever one does, it should be a Samskrita, well done. It will be well done if it is done according to one's duties. If one performs everything according to duties, he would never have violated law, but he would have walked on the path of Dharma. Law gets merged, subsumed in Dharma, and law does not stand apart from Dharma. Thank you very much.
This Subramaniam, Dean Planning and Development, to present a memento to Shri K.Parasaran. I call upon Dr. Kannan to propose the vote of thanks.
श्रीमान वेंकटनाथार्य कवितार्किक केसरी वेदांताचार्य वर्गो में सनिधत्ताम सदा हृदय. Basically, I am a professor of mathematics, so I start with permutations. The concept of permutation is found in our ancient scriptures as early as in Pancharatra Agama. Lord Vishnu has 4 hands and there are 4 objects: Shankha, Chakra, Gada, Padma. These 4 objects should be placed in the 4 hands of Lord Vishnu in how many ways? So Pancharatra Agama gives the answer in permutation. That's what you study in your plus 2. 4 factorial. That is 1 into 2 into 3 into 4, 24 ways. That is why we have 24 forms of Lord Vishnu as Keshava, Narayana, Madhava, Govinda, Vishnu, Madhusudana, Trivikrama, etc., etc., Adhokshadan, Hari. So the permutation concept is found in Pancharatra Agama. And the first and foremost name is Keshav. So whenever we utter that word, immediately we are reminded of Sri Keshava Iyengar, the father of our chief guest, K.Parasaran. And Keshava Iyengar was a colossus. He was a great Sanskrit scholar. He has written indelibly in the scroll of fame by his writings. And in 1940, when the renowned pontiff of Ahobilamat, His Holiness Shri Intimate Aragesinger, was introducing a Math publication of Adhikarana Saravali as unequaled work of Sri Vedanta Desika, with the commentaries of Sri Kumara Varadacharya, son of Sri Desika, to great scholars, acknowledgement was made to Sri Kesavayangar Swami in front of Attipatta Aragesinger and Sri Tevanarvala Aragesinger in Purvashramam. They were all veteran scholars of Sanskrit. So he was such a competent master of Sanskrit as well as Tamil, whom it is a pleasure to quote now. He has authored several works, and I have studied some of the books. He has translated the whole of Paduka Sahasram, magnum opus of Sri Vedanta Desika, in Tamil verses, known as Thiru Padukamalai, in chaste Tamil, without losing the charm and beauty of that work. And Valluvar Ullam, he brings out the thought of the mind of Valluvar. And for example, he gives the innovative commentaries for each and every Kural. If you take the third Kural of Sirappu Payiram, Kadavul Vanakkam, Malarmisai Yehinan, Manadi Serndar, Nilamisai Needvalvar. Malarmisai Yehinan, Manadi Serndar, Nilamisai Needvalvar. This is the third Kural. He says here Malar represents Pushpaka Viman, Pushpaka. Yehinan is a Tamil word that is not used for sitting. Yehinan means somebody going fast. So Malar means a Yehinan. After killing Ravana, Sri Rama boarded the Pushpaka Vimanam and hurried back to Ayodhya in jet speed to rescue Bharata from jumping into fire because he would not bear the delay beyond 14 years. So Malar means a Yehinan, Manadi Serdar. Those who surrendered Rama, Nilamisai Needvalvar, they will live in this world as Chiranjeevi like Vibhishana and Hanuman. So he says this particular Kural is only for Ramavatar. So like that there are several innovative commentaries in this book Valluvar Ullam. He quotes Desika in this context, Pushpakarabhasagati Goshpadi Krita Gaganarnava from Raghuvira Gadyam. So no doubt K.Parasaran excelled in everything. Just giving the summing up his lecture in 1 minute will be like drinking the whole Milky Ocean by a small cat, as Kamban says in his Sirappu Payiram. ஓசை பெற்றுயர் பார்க்கடலுற்றரு பூசை முற்றவு நக்குபுவிக்கென ஆசை பற்றி அறையலுற்றேன் மற்ற காசில் கொற்றத்து ராமன் கதையரோ. ஏவம் நிஜ யசோதவலீகிருத திகந்தராளஸ்ய यशोधवलीकृत दिगंतरालाय श्री केशवार्य पुत्राय श्रीमते पराशर वर्याय शास्त्रा विश्वविद्यालयः निज धन्यवादान् सप्रश्रयं सांजलिबन्धं समर्पयति. The fastness of Rama's arrow is described in two words. Two words means compound words. Two samastapadam. Two compound words in Raghuvira Gadyam Sri Vedanta Desika. I will recite those two words. Sita Saragrita Lavana Dasamukha Mukha Dasaka Nipatana Punarudaya Daragalita Janita Daratara Harihaya Nayana Nalina Vanur Chikatita Nipatita Surataru Kusumavitati Surabhita Rathapatha. This is one word. Akila Jagadadika Buja Balavara Dasalapana Lapana Dasakalavana Janita Kadana Paravasar Deni Tarapati Vati Lapana Vachana Samavisha Nigama Shikara Nikara Mukara Mukamunivara Paripanita. This is the second word. So Vedanta Desika says, he claims that you can see the fastness of Rama's arrow through my literature. And that fastness of Rama's Shastra is personified as Shastra's Rama as our Vice Chancellor. So he is ruling this esteemed university. You can see that fastness in his actions. So Asmai Shastra Vishwavidyalaya Kulapataye Kula Pitrecha Shri Seturama Varyaya Pranati Purasaram Dhanyavadaha Samarpyante. Adi Shankara Bhagavad-pada says, he describes the achievements, he narrates the achievements of Lord Subramanya through several stanzas in his Subramanya Bhujangam. And finally in the crowning verse, vicious Lord Muruga always success, Senani. That Senani is our Vaidya Subramanyam. He is the Senani of our Shastra University. So, Shri Vaidyanatha Subramanyaya Sada Jayam Asam Samanaha Tameva Subramanyam Prarthage Jayananda Bhuman Jaya Paradhaman Jaya Mogha Kirte Jayananta Murte Jayananda Sindho Jaya Sesha Bandho Jayatvam Sada Mukti Dahane Shasuno Sarvebhyaha Sarvabhyascha Sanjali Bandham Dhanyavadaha Samarpyante Iti Sham. Thank you.